I do want to ask you this, Michael, because we have this issue where she was on the stand. The jurors have been able to ask questions throughout, and they had their questions ready. They'd already submitted their questions to the court, but those questions didn't get to be asked of this defendant because she didn't take the stand. Do you think, if we're talking about an appeal and whether or not she could raise that issue, she did waive her right to be there, that's in writing, but does that prejudice the jury in any way, where they see this person who had been on the stand, they had questions, and then she's not there to answer their questions? It's a new situation in Michigan for these judges to allow these questions, but do you think that that could prejudice them negatively against her?
Absolutely, 100%. There's going to be an adverse inference against her in the minds of the jury, 100%. No questions asked, because listen, your child died and you're not even here for the trial. There's no medical, you were not hit by a bus in the middle of the trial, right? You're just sad, and you're regretful for your actions, and you were not here to answer our questions. On top of that, this jury is going to be a very conservative jury. She's done. She's cooked. It's a cold day literally, and it's a cold day figuratively for her attorneys. They have their jackets on, but they can't get warm enough getting into this. Is going to be miserable. If I was a defense attorney going in to the reading of that verdict, or even going into the closing arguments, I mean, I would need a drink the day before and the day after. I mean, it would be mind-boggling. By the way, as a former public defender, I've had to defend a couple of cases where I didn't want to, and the judge took me aside and said, please don't quit this case. I know you want to quit this case. I would quit this case, but you got to pay your dues, young man. Stay on this case, right? So this has a tinge of that.